Hello everyone and welcome to this special weekday Motor Trade Radio podcast, powered by Motors, the driving force behind multi-site advertising, with Philip Nothard and Curtis Hutchinson, bringing you all the chatter that matters across the franchised and independent dealer sectors.
Delighted to welcome this week's special guest, Jonathan Butler, the joint head of automotive at Geldard, the national law firm, and legal counsel to the Vehicle Remarketing Association. The big story still being digested by the car retailing sector is last week's Supreme Court ruling on how car finance is sold, and the subsequent move by the Financial Conduct Authority to launch a redress scheme for car buyers who believe they were missold finance under Discretionary Commission Arrangements dating all the way back to 2007. Now, following the ruling, John posted a blog on the Geldard's website, which neatly rounds up and explains the ruling from a legal perspective, which we really urge listeners to read. I particularly enjoyed the Motown referencing title, which is Stop in the Name of Automotive, a common sense judgment from the Supremes. Car finance claims take a hit, which kind of gives a flavour of where Jonathan's coming from. So we're delighted to welcome John to make sense of it all and discuss the ramifications for dealers. So welcome to the pod, John. Has the dust settled for you yet? I should imagine it's been a fairly intense period since last week.
It has indeed. Thank you very much for having me. The dust has settled a bit, but there's still lots going on.
Yeah. I mean, obviously we're recording this ahead of when it goes out. So, in the world of automotive and everything else going on, anything could happen, couldn't it, John? Before now,
it could.
Yeah. So, I mean, as I say, I mean, the dust has settled, but there's still a lot to sort of get through with this, and it seems a long while ago where we had your colleague on talking about when it was initially done or the case started, and now we've now got the judgment. So, I mean, obviously, it is a complex case for the sector, and for those that may not be as close as yourself, and I've been trying to follow it closely as well. And, for the sector, and it's complex for the car buyers. Could you give it some context and explain, in as briefly as possible, what prompted the Supreme Court's involvement?
Sure. Okay, so there were three conjoined appeals brought by what the court described as financially unsophisticated customers. And each of those customers had bought a second-hand car from dealerships, which also brokered the finance. As a result, the dealer brokers received a commission from the relevant lender that had either not been disclosed or only been partially disclosed. And the three customers brought claims in the county court, alleging that the commissions paid by the lenders were bribes and that the motor dealer's acceptance of the commissions effectively amounted to a breach of what is called a fiduciary duty, for which the lender bore accessory liability. One of the customers, Mr. Johnson, he claimed that the payment of the commission made the relationship between him and the lender unfair within the meaning of the Consumer Credit Act. Now, all three customers were unsuccessful in the county court, either at a trial or on appeal. They then appealed to the Court of Appeal, where their appeals were heard together, and then last October, in the shock judgment, which surprised the sector and most lawyers, they were surprisingly upheld. And the Court of Appeal in that judgment basically said that in all three cases, the dealer owed the customer a disinterested duty and a fiduciary duty when performing their credit brokering role. The customer's informed consent to the payment of the commissions could only be obtained if they knew its amount. Mr. Johnson had not given his informed consent to the payment of the commission, and that relationship was therefore unfair. And as a result of that judgment and all the furore that was caused after it, both lenders appealed to the Supreme Court, the final Court of Appeal in the UK, and they handed their judgment down on the 1st of August, as we all now know.
And from a legal perspective, a legal point of view, what did the ruling encompass?
Well, there were permission was given on 6 grounds to appeal, and I won't go through all those in detail. But the Supreme Court framed the issue effectively as this: does a car dealer who receives a commission from a lender for arranging finance in a transaction between customer, dealer, and lender, in which a car is bought on credit, owe a duty to the buyer of the car so as to enable that buyer to bring a claim against the lender for bribery or dishonest assistance, or under the Consumer Credit Act? And as part of that issue, the sub-issues that the court had to look at was, does the law recognise a distinct tort, if you like, or wrong of bribery? And if it does, what's the nature of the duty or relationship between the dealer and customer that must exist in order for that bribery to be engaged? And then connected to that, what level of disclosure would prevent liability for bribery arising? And in Mr. Johnson's case, was the relationship between customer and lender unfair under the Consumer Credit Act? So the Supreme Court, in analysing those issues, decided unanimously that motor dealers acting as credit brokers do not owe a fiduciary or special duty to customers. They operate at arm's length, pursuing their own commercial interests. No reasonable person would think otherwise, nor do dealers pretend or promise otherwise. So they are not bound by the single-minded loyalty required of fiduciaries. The court said that the Court of Appeal had fundamentally misunderstood a dealer's role, and as a result, lenders couldn't be held liable for bribery or dishonest assistance by virtue of undisclosed commissions paid to the dealer. And only in Mr. Johnson's case did the court uphold a claim under Section 140A of the Consumer Credit Act that there was an unfair relationship. And it highlighted a number of factors that it thought were relevant for the purposes of deciding that that relationship had been unfair.
Now, John, you've actually explained what is a very complex ruling and background, and you've explained it in a easy to follow, easy to understand way. And as part of the analysis that you've shared over the course of the last week, you've actually got 3 key takeaways, which will really resonate with a lot of our listeners. What do those 3 takeaways cover?
Yeah, okay. So first of all, I think that now the industry will be able to assess really what their exposure is. I mean, this is a positive outcome for dealers. Lenders are expected to bear the compensation burden, not the brokers. But the lenders should now be able to determine with some certainty whether their brokers owe fiduciary duties, and at a high level will be better able to assess the likelihood of success of any unfair relationship claims made against them via the regulator or via the courts. That will help them determine their potential liabilities and make provision. It will also mean that dealers are going to have to look back historically at records, some going back a very long way, to work out what the transactions were, what they said, what they disclosed, what they didn't say, whether they've met the relevant thresholds. And thirdly, that will also help them decide how best to deal with ongoing claims that are still being widely advertised. I mean, you have seen that adverts out there, particularly by claims management companies, have not slowed. They're still out there. That adverts are still being put out there, which almost reflect the position before the Supreme Court judgment. I'm surprised actually that the FCA has not ordered that those adverts stop pending them rolling out the redress scheme. But people should now be able to see really and navigate where they're going with these claims and make sufficient provision.
And just really taking each of those takeaways in order. I mean, firstly, in terms of the payouts, what will this mean for the finance sector? There's been a lot of numbers and a lot of potential costs being talked about, which are fairly broad in terms of their estimations.
Yeah, the estimation is that there's going to be somewhere between, I think, 9 and 18 billion pounds. My own view is that figure may be to try and ring fence potential exposure, but it's probably implausible. It seems to me way too high. £950, which is being considered the maximum claim per agreement, divided into 16 billion pounds, whatever it is, 18 billion pounds, is looking at something like 10 to 20 million claims. Those claims, all to the required thresholds, seem to be highly unlikely. It's not impossible, but it seems that that's a lot of people who will have to prove demonstrably that they have been unfairly treated.
And probably the second one is obviously in terms of the legal obligations facing, as you'd say, those dealers, and we're talking about going back to 2007 here. I mean, and they've obviously started it since 2007. What was the reason for that, and what are the obligations now from the dealers?
The reason for that was that the FCA proposed that the scheme covers agreements going back to 2007 so that it's consistent with the Financial Ombudsman Service complaints that are already being considered. But whilst the FCA has said that it wants a scheme to be comprehensive and avoid the need for consumers to use other routes to secure compensation, and also to prevent large numbers of claimants going to court, it's unclear actually why anyone can go back to 2007 realistically when the limitation period for pursuing claims is typically 6 years. But be that as it may, 2007 is the date that the FCA has chosen so that it aligns with what it's already been done. And in terms of what legal obligations face dealers, first of all, it's meaningful disclosure. I mean, they're going to have to access somehow historic agreements. And the dealer groups that I've spoken to, there's just no chance that they've got data or documentation going back anywhere near that far. They didn't face regulation until 2014. So it's all very well saying that the scheme should be properly thought out and it should assess claims properly and rigorously and not arbitrarily. But how can that be done when claims from fairness are going to be inevitably highly fact sensitive? And if you don't have the data or the documentation to interrogate, how can anyone make a proper assessment as to whether a claim being brought is genuine or not?
And thirdly, and I know I've spoken to you a lot about this with the work that you've been doing with the VRA and others, that explain the indemnities that the dealers need to obviously check in their contracts with their lenders, and what happens if they find that there is indemnities, or what the case is, or with and without these indemnities.
Yeah, it's a great question. Invariably, dealers will have agreements with their lenders, and those agreements will contain contractual provisions which typically provide that in the event that the dealer's compliance or non-compliance or any other aspects of the relationship bring about loss to the lender by virtue of claims, regulatory prosecutions, fines, demands, whatever. However, the dealer's conduct has effectively landed the finance company in it. Because you have to remember that the dealers, they're the coalface, they're the ones that are dealing with the consumers. The lenders are beholden to the dealers to do their job properly. And to the extent that the dealers have not, then there may well be contractual provisions in the dealer agreements that say in those circumstances, any loss that the lender suffers should be paid for by the dealers. So it's good practice now for dealers to have a look at those dealer agreements and see if there are indemnity provisions in there, to take advice if they are in any doubt, but also if they are there, and they typically will be there, to obviously reflect on the commercial relationships that they've got with the lenders. Lenders need these dealers. They'll typically not fall out with each other. There are commercial means of sorting these issues out. But in the right circumstances, there will be lenders who might be looking to the dealers to reclaim some of the loss that they will suffer as a result of this redress scheme. And so dealers need to understand that. They need to work out what their potential exposure is for it and make provision.
And John, following on from that and looking at the FCA's redress scheme, which I think our understanding at the moment is that it will be set out in October with a clear deadline to be completed in terms of redress being made sometime in 2026. And this is based on the Johnson versus First Rand ruling, where the commission paid on a car purchase made by the initial car buyer, Marcus Johnson, was set at something like 55% and was undisclosed at the time as a paid commission and was subsequently upheld by the appeal court. What are the legal implications of this for dealers? Because it's really focusing in on that unfairness, isn't it, of the actual commission paid?
It is, but the redress scheme won't be isolated. It won't be confined to that. The FCA has already indicated that they will be looking at agreements that contained DCAs or discretionary commission arrangements, so that those practices were banned back in 2021, where dealers are effectively incentivized to charge higher interest rates in return for higher commissions. That will be part of the consultation, as well as agreements that don't contain any discretionary element, such as the ones that we have been talking about before the Supreme Court. So the consultation will be quite broad. It may even go wider. The court made no mention of regulated hire agreements, not hire purchase, but hire agreements.
Yeah.
And nor does the Consumer Credit Act cover regulated hire agreements in Section 140 for these purposes. So it may well be that the redress scheme has got to broaden the scope yet further and consider whether commissions that have been effectively improperly paid in those circumstances ought to be subject to some form of redress. So it could be pretty wide, and I think as we've already been discussing, the legal implications for dealers are they've got to look at how far they are exposed. They've got to go back through their paperwork, such as there is, and try and work out what potential exposure there is, and whether, as we've said, whether they are on the hook for indemnities by lenders.
Yeah, it's very complex, isn't it? I mean, I've heard dealers now that have since 2021 been accruing for potential interest rebate on that obviously I think there's this, is it 3% they put in, but it's an average. They average it, don't they, over the period. So some dealers have already accrued, hundreds and thousands up to millions of pounds in their accounts, just in case there is any redress that will be passed on to them in terms of those interest charges.
Yes,
so
and the dealers have to remember as well that we're looking at a period of 14 odd years, and there may well be customers who purchased maybe 3 vehicles during that period on PCP or HP arrangements. So there could be customers with 3 lots of claims. So they need to be obviously looked at. Interest, yes, you're right. It could be about 3%, I think 1% above base, or about 3 altogether. It's roughly going to be around that sum. If I could just add, even though the FCA has announced that these payments will start in 2026, I think that sounds pretty optimistic.
They didn't say when, John. They didn't say when.
No, that's right. They said hopefully implement this scheme in 2026 and payments starting in 2026. I suspect that could be the back end of 2026 at the earliest, because I just don't see how practically possible it's going to be. Because unless compensation payouts in demonstrably unfair cases are approved and quantified on an arbitrary basis without a forensic assessment having been carried out for each one, I just can't see how the FCA can logistically do it.
And do you agree with, there's some people are challenging why it goes back to 2007, but some part of the sector believe that that's a good thing because it closes down the claim risk because it's, if you go back before then, but the actual case goes back to 2007, you run the risk of going back into the small claims or individual claims.
Yes, I think it probably is a good catch-all. It may not work in terms of logistics and trying to find documentation and data and information. But if it catches everything and gets this sorted out once and for all, then that's probably a good thing.
Yeah, I mean, it's fascinating, and I know, I mean, trying to get this into a 20-minute conversation to try and cover it with is so complex. But I mean, just finally, you describe the Supreme Court's ruling as what you call as common sense judgment. I mean, what should dealers do now to ensure that they remain compliant? I mean, you touched on it a bit in terms of checking their contractual agreements, checking their indemnities, but actually thinking of going forward just to make sure that they are compliant to any exposure and the new rulings.
Yeah, it is a common sense judgment. I don't think anyone in their right mind was expecting anything else. This is not a huge surprise to the sector or the law firms up and down the country. I think everyone balked at the Court of Appeal judgment as being extremely odd. But looking ahead now, dealers need to go back to their historic commission arrangements to ensure that they fall within acceptable transparency thresholds. That's the watchword, transparency. They've got to monitor FCA guidance and any future scheme implementation, including obligations to participate or respond to consumer complaints. They need to prepare communication strategies to address existing customer queries and manage their reputational risk. There's probably going to be an obligation on all such dealers to notify their customers that they've got potential claims, even the ones that don't yet know. I mean, I'd be surprised if no one knows, but you're going to have to tell your customers that there are potential recourse out there. Dealers are going to have to audit their contracts with third-party claims handlers, particularly as we've talked about, where indemnities or referral relationships might be implicated. And they're also going to have to support internal teams in handling data subject access requests from consumers prompted by renewed public interest. Because even though I think widespread people know that something cataclysmic has just happened to the claims management environment, whereas there was or seemed to be clarity as of Friday evening on the 1st of August, by Saturday, the FCA had managed to confuse everybody and make sure that everyone then thought, actually, there's still billions of pounds of the claims out there potentially. So I think you are going to get consumers who've not yet signed up to claims management companies asking for details of data and agreements, etc., that are held by the supplying dealers. And they may well register with claims management companies to try and bring claims for unfairness, even though the courts are saying that, and the FCA is saying that they don't need to do that. And of course, there will be people who've already signed up to claims management companies wondering now what's going to happen to those claims.
Isn't there an exit fee?
Yeah, well,
I mean, sorry to throw it in about at the end here, but there are consumers that have signed up to more than one claims, and there are exit fees that apply to these.
Well, doubtless there'll be people out there having booked world cruises on the back of promises that they're going to get thousands of pounds for each of these claims. And I suspect that they're going to be falling out with claims management companies before too long, saying I've been misled and I wouldn't have signed up to this agreement had I been told correctly that I didn't need to do so, because I could have gone straight to the FCA. And then claims management companies are going to say, well, if you want out, you're going to have to pay us 175 quid to get out. And that's going to bring about claims that they've been treated unfairly. They'll go back to the FCA. The FCA will be dealing with unfairness in satellite litigation, let alone the core litigation about the particular treatment by dealers to consumers. So it's a bit of a mess. And the FCA is going to have to be very careful in rolling out this scheme, because if it's not careful, it could just end up reaping a situation that's far worse.
I could hear you laughing in the background there, Curtis. I mean, trying to make sense of it all, and
if you're a claims management company, you've got to kind of ask yourself: do you pursue these claims for limited unfairness now of a maximum £950 and take 36% of that and run the risk of the ire of the customer? Or do you let the consumer out and fight out with the consumer over an exit fee of £175? What's your business model? Are you going to just going to guarantee yourself 175 quid in a fight, or are you going to run the risk of losing everything with all your investment for the sake of a third of 950 quid?
Yeah.
Lots of these companies have ploughed a lot of investment into these claims. And now that the test is about unfairness on a highly fact-sensitive case-by-case basis currently, they're going to have to put more and more investment into those claims to win them. Far more investment than they were having to do up until last Friday. And I imagine there'll be lots of CMCs now wondering whether their business model is actually viable.
Yeah, I think you're absolutely right, because that's a lot of £175. And I was particularly interested in what you were saying about the FCA potentially getting involved at some stage. So as you say, that part of it is all a bit of a mess.
It is.
And I mean, you could say this is a ever-moving situation, and there's a very complex and things like that. But I think you're trying to keep ahead of it. It's really great to have you on, Jonathan. And as I said, to try and contain this into sort of less than 30 minutes is a feast in its own right. But I mean, if anybody listening hasn't seen John's and Geldard's blog, then it's a great summary of the outcome and their opinion on it, albeit as agreed, what a great title on that one, and it's placed very much into Curtis's space with that headline.
If I could just say, lenders and dealers were always right to fight this. It always seemed wrong, and I applaud them for seeing it through, because even though it's still not clear how it's all going to be resolved, they're in a much better environment now than they were before a week ago.
Yeah, and consumer lending in the broadest industry in its own right, isn't it? I think that it's contained to this, and it hasn't been let out into, consumer lending and B2B lending, etc. That it's a good result, although it is going to still hit financially in some areas. It could have been a lot worse.
Yeah, absolutely.
But that's all for now. So many thanks to John for joining us, and many thanks to you for listening. Until next week, it's goodbye from me.
And it's goodbye from him.
Thank you for listening to the Motor Trade Radio podcast, powered by Motors, the driving force behind multi-site advertising. We'll be sharing all the URLs from this week's headlines on Monday morning. To make sure you receive them, just subscribe to the free newsletter on our LinkedIn page. Just search Motor Trade Radio Podcast.